Good afternoon, everyone. For those of you who don't know me, I'm Jason Bailey. I'm with the firm of Sheets and Bailey. We have an office in Liverpool. Our practice is dedicated to commercial and industrial construction. We represent everyone from owners down to suppliers and everyone in between, including design professionals. We're going to talk about liens and payment bonds today. But before we get into all that stuff, I want to introduce you quickly to a friend of mine who will also be speaking, Mike.
Nice to be here. Thanks for the introduction. My name is Mike Tresidder. I work for Insurance Office of America as the Director of Surety. I, before that, worked as a surety underwriter for 12 years for Liberty Mutual. And at IOA, we have offices around the country. Locally, we have an office in Syracuse and an office in Binghamton. So, thanks.
Yeah. So before we get into the nuts and bolts, I want to go over a couple things. First off, I want to thank Tracy and Phil for allowing us to put on these webinars and to host the webinars and provide the information, serve as a conduit for the information from us to all of you. So to just give you a general overview, we're going to try to do 3 webinars. Today will be the first one. It's going to discuss mechanics liens and payment bonds, kind of the basics of each of those topics. We could spend hours on each one of them, but we're kind of just going to give you the view from 10,000 feet. The second webinar will be on human resource issues and insurance. Since I know little to nothing about insurance, I won't be doing that. A colleague of mine will be, as well as colleagues of Mike's. And then the third webinar will be on claim management. What do I mean by that? Well, if you're on a construction project and a claim arises, a delay, a disruption, extra work, anything that you can think of that you think you're entitled to either additional compensation or additional money, or to fight a claimant that is seeking additional compensation or additional time on a particular project, we'll give you some information on how to identify it, how to put the applicable people on notice per the terms of your contract or subcontract, how to track it from a contractor's standpoint. We'll have people that have actually built multi-million-dollar projects, and we'll detail all that for you. And then you'll hear about it also from an accounting standpoint and potentially even from an insurance standpoint. So the claim management webinar will probably be a little bit lengthier than this one or the human resource insurance webinar, but it'll be chock full of information. And with each of these, our hope is to give enough of a break in between each webinar to allow you guys to submit questions between. So in other words, today we're going to do a webinar on liens and payment bonds. You'll have a period of time after this is published and after you've reviewed it to submit questions to Tracy or Phil. And then Tracy or Phil will then direct all of those questions to Mike and I so we can review them, provide written answers to the extent possible, and then Phil and Tracy will publish the questions and answers before or at the next webinar publication. So hopefully there's a constant turnover of you get one webinar, you get question and answers, you get the second webinar, so on and so forth. And the last thing I'll mention before we start getting into the meat of today's discussion is the difference between webinars and live seminars. Mike and I have done this before with a live audience for both Mohawk Valley and Northern New York. I've only done a couple webinars, and I think this is Mike's first. There is a huge difference in talking to a lens versus talking to a live audience. I much prefer talking to a live audience. It breaks up the monotony of my presentation, of my voice. It also allows me to answer questions about real life situations from the audience. So forgive us if we seem a bit robotic up here. This is not our normal practice. So with that, let's jump into mechanics liens and payment bonds and what you need to know.
I do have to say one thing. I feel much more comfortable today than our last presentation, and that's because I had an accident driving to the Mohawk Valley Builders Exchange location, and so I came in flying hot from a car accident.
Yeah, it was actually the first time we were presenting together, and Mike was late, and I'm sitting there thinking to myself, where the heck is this guy? We get this opportunity to present some information, and he's going to show up late. So he comes in and he says, I was just in a car accident. I look at him, he's clearly okay. Well, I go out and look at his car is clearly not okay. So it was an interesting start to the first, I think it was the first seminar we ever put on together.
I think you're right.
Yeah, it was interesting. But anyway, so with liens, let's get into it. It's one of the most common questions I get from contractor clients. Hey, I haven't been paid on a particular project. I want to file a lien. What do I do? How do I protect myself? And so there's always a series of questions I have to ask the client. And one of the things I always tell them early on is a lien is not this magic bullet. It is not the thing that always guarantees you payment. It is an arrow in your quiver. It's something to use that hopefully leads to you getting paid. In some instances, I can file a lien and it leads to a payment within a short period of time. In other instances, I file a lien and it has little to no effect. Why is that? Well, I'll explain that as we're going today. But first, what is a lien? A lien is different depending on whether you're on a public or a private job. On a private job, a lien serves as an actual interest in the physical piece of property where you're performing the work. So if you're performing work, say at a Walmart, and you don't get paid, and you file a lien, that lien attaches to the physical piece of property where that Walmart sits. It's almost like a mortgage on your property. You live in your home. You owe the bank a lot of money in order to actually own that home outright at some point in time. And in return, the bank takes a mortgage out or has an interest in that property. So if you don't pay that loan every month, right? If you don't make your payment every month, then the bank has a right to foreclose on that mortgage and physically take that piece of property back from you. Same basic concept applies with a private lien. Your lien puts everyone on notice that you have an interest in that physical piece of property. So if the owner wants to sell or refinance that piece of property, the lien more often than not stands in the way, at least initially, because a potential buyer is going to see it, or a bank is going to see the lien in place and say, well, wait a minute, I don't want to give you, buyer, money to go buy a piece of property that's subject to a mechanics lien. So a lien on a private job is an interest in a piece of property. A lien on a public job, very different. The government doesn't want to give you the right to have an interest in a school. They don't want to give you the right to foreclose on a school and be able to sell it. That's just never going to happen. So instead of a lien attaching to a piece of property on a public job, it attaches to a fund of money. For almost all public jobs, before the job even starts, a fund of money is set aside to pay for that work. $40 million new K through 12, right? The money's set aside for that project. When you file a lien because you haven't been paid, it attaches to that fund of money, not to the physical piece of property. So one of the other questions I get oftentimes is, how long do I have to file a mechanics lien? And the second question is, when should I file the mechanics lien? The first answer, or the first question, is rather easy to answer. The second question is a little bit harder. On a private job in New York, let me clarify. On a private commercial construction project, i.e. not residential, you have 8 months from when you last supplied labor or materials to that project to file your mechanics lien. If it's a residential project, you're doing work on someone's home, you have 4 months from when you last supplied labor or materials to file a mechanics lien. On a public job, you have 30 days from when the project is deemed completed and accepted. Now, what does that mean? Unfortunately, it isn't exactly defined. For some public projects, there'll actually be a form that the architect or the designer of record will submit where someone, including the owner, the architect, the contractors, or some combination thereof, deems the project to be accepted and complete. That's not universal. Some could make an argument that upon, say, substantial completion, i.e. beneficial use of the project, it is deemed complete and accepted. Unfortunately, there is no bright line test, but generally just know that you have 30 days from when the project, not your work, is deemed completed and accepted to file a mechanics lien. So now we come to my second question on timing. Those are the cutoffs that you absolutely have to meet. If you don't meet those cutoffs, you forever lose your right to file a valid lien. But the second question contractors ask me is, when should I file it? Not when is my absolute last day to file it, but when should I file it? And that's a little bit harder to say because politics are involved. You have to decide what is going to happen if I file this lien. Are people going to dig their heels in? But you also have to weigh it against this concept known as a lien fund. And the lien fund is different than what I talked about on a public job before. It's a little bit different. The lien fund is actually an example of New York getting the law right. The lien fund concept prevents or precludes an owner or a general contractor or a subcontractor from having to pay someone twice for doing the same amount of work or for doing the same work. Here's what the lien fund is. Let's say an owner has a $5 million project and they have set aside $5 million to perform this work, whether it's private or public. And the project is 50% complete. So there's $2.5 million that has been paid out to the general contractor thus far. The lien fund at that point in time is $2.5 million. It's the amount that's left that hasn't been paid out. So why is that important? If the general contractor took the initial $2.5 million and didn't pay any of his or her subs, and they all filed a lien for the money that they're owed, $2.5 million, let's say, they'd be able to get paid because the lien fund that's left is 2.5. But let's say they were closer to, let's say the general contractor had been paid $4 million on that same project, but didn't pay any of the subs and suppliers. And there are $3 million in claims, in liens that get filed. The owner only owes the general contractor, should the general contractor complete, $1 million. There's only $1 million left in the lien fund. So the subs that file liens can only ever get access to that $1 million. If there's only one lien, well, you can get the entire $1 million that's left. If there are 10 subcontractors totaling $3 million in liens, you're still only going to get a piece of that $1 million. And typically, it is broken up pro rata. In other words, if there's $3 million in subcontractor claims and $1 million in the lien fund, the owner typically says, hey, I'm just going to pay each of you pro rata a piece of the $1 million. You still have a right to go after the general contractor for breach of contract, maybe even trust fund diversion. We'll get into that later. But the concept of the lien fund is important because you're going to always be limited by the amount that's in the lien fund, and it might persuade you, that limitation might persuade you to file long before your deadline. In other words, on a private job, you have 8 months from when you last supplied labor and materials. But if you got a feeling that there isn't much left in the lien fund because the project is far along, you might not wait 8 months. You might wait 2 months. That's a business decision you have to make. So because of the lien fund, you have to be mindful of when to pull the trigger on filing that mechanics lien. Now, who can file a lien? It's a really broad category. It's pretty much anybody that improved the project, that added value to the actual physical project. If you've done that in broad terms, you can file a mechanics lien. So even laborers working for a contractor or subcontractor can file, a mechanics lien. On a public job, however, only the first and second tier subcontractors and suppliers can file a mechanics lien. So if you're too far down, if you're too far removed from the general contractor, then you can't file a mechanics lien, at least not a valid one. Another general rule is suppliers to suppliers can't file a mechanics lien. So switching gears real quick, what's the duration of the mechanics lien? So you do your work, you don't get paid, you file your mechanics lien before your deadline, and while there's still money in the lien fund, how long does it last? Well, the mechanics lien, the first filing the mechanics lien lasts 1 year. You can renew it for an additional year, provided you renew it before the expiration of the original filing. So in other words, if you filed it on March 1st, 2020, you need to file the renewal before March 1st, 2021. It's then good for another year. Then at the expiration of the renewal, so essentially 2 years after you initially filed, the lien will expire unless you commence an action and file a lawsuit and seek to foreclose that mechanics lien. Now remember, like I said before, mechanics lien is like a mortgage on your house. You don't pay the mortgage on your house, the bank forecloses, tries to take your house. With the lien, it's sitting there really until you foreclose on that mechanics lien, and then you essentially start taking steps to physically take the piece of property where you performed the work.
I do have an example of an actual private lien and the foreclosure process coming to bear fruit. Basically, a general contractor agreed and negotiated with an owner. The owner provided confirmation of financing. They felt comfortable with the confirmation of financing, proceeded with work, signed a contract, and got into the job to the tune of multiple millions, and the financing went away. So the confirmed financing actually never came through. The contractor was left holding the bag for multiple millions of dollars, and in essence had to file a lien, and it took quite some time for that to actually the process to work out where the lien was perfected and they now own the property. From a surety perspective, what it does is it can create a financial issue because that asset is typically a receivable, and it's a receivable that will sit on the balance sheet for who knows how long. What have you typically seen for the duration of a liened property?
Well, litigation has the potential to go on for years. Lien foreclosure is even more complicated than a classical breach of contract claim, and it almost always adds time. So if you're going to foreclose on a mechanics lien and the other side is going to put up any amount of fight, you're going to look at a minimum of a couple years. So it's sitting on the balance sheet potentially for a couple years.
And until that's actually able to be converted into cash or financing comes through, or the owner's able to pay monies, that's not a good situation from a surety's perspective.
Yeah, because
Usually that asset would be disallowed, and it can just create issues. In this case, things did work out, but
because from a surety standpoint, you're looking at if a contractor comes to you and says, hey, I'm going to do a public job, I need a payment and performance bond. Or, hey, there's a problem and I need a lien discharge bond. When they come and ask for a bond, you guys don't want to invest in a contractor that might go belly up. So you're looking at their financials, right?
correct.
And so you're saying if a general contractor has a situation where a project goes belly up from an owner standpoint, and a general contractor or a sub files a mechanics lien seeking to recover, and they think, hey, Mr. Surety, I'm owed $500,000. I did the work, and I got this mechanics lien in place. I'm going to get paid. You look at it from a balance sheet standpoint as I'm going to discount that $500,000 receivable.
Correct.
Yeah. Okay. Okay. So, all right. So with liens, one of the things you may hear when they get filed, or when you threaten to file it, is the general contractor might threaten to, I'll just bond it off. I don't care. File the lien. I don't care. I'll just bond it off. That should be music to your ears, because when they bond it off, a company like Mike's steps in on some level and provides a bond that says, hey, instead of your mechanics lien physically attaching to that private piece of property, or instead of your mechanics lien attaching to the fund of money on the public job, that mechanics lien now is going to attach to the bond that I, Mr. Surety, am going to provide to the contractor. And I, Mr. Surety, am going to stand behind that bond. In other words, if you foreclose on the mechanics lien, now you're foreclosing on the bond. So now instead of just suing the general contractor, you're suing the bonding company. And Mike won't like this, but this is what I tell clients all the time. Bonding companies are like insurance companies. They're usually in good shape financially, have the ability to pay, and juries really don't like whenever you say, hey, my client is suing an insurance company. So what I always tell clients is, if someone tells you, hey, I'm going to bond off your lien, and says that as kind of a threat to you, you should like it. It provides another deep pocket for you to chase, and an easier deep pocket. So Mike doesn't like it, but I do.
And functionally, usually when there's a lien in place, that's when the surety attachment point would come into play. Is a client, a GC, or if it's even a mechanical, electrical, you name it, that has the prime contract that's now being liened, we typically get a request for a discharge of mechanics lien bond, or you could say bonding off the job, also referred to as a DML bond. And typically, sureties do not have a great appetite for DML bonds. They're indicative of issues on a project, of issues between a sub and a GC. And for a client in good standing that's financially strong, sureties will readily approve them, although on a one-off basis, typically it's not a preferred type of bond that sureties are looking to write. The DML bond itself, like I said many times, there's just issues with the project going on, and any surety is probably going to ask for some kind of explanation of what's going on with the job, what is the situation here exactly, and want to have a full understanding and narrative of the situation going on.
So on some level, depending on the contractor that is not paying you, a filing of a lien for which the contractor has to bond off can create a leverage point on some level for some contractors, because a company like Mike's or a person like Mike is going to approach the contractor and say, I have to bond off, you've asked me to bond off this lien or all of these liens. What's the problem? What's going on? And then they're probably, depending on the contractor, may reevaluate the contractor's financial wherewithal because they don't want to enter into a bad investment. So it could potentially be a leverage point of filing a lien. It's not a magic bullet. It's an arrow in your quiver. We talked about what a lien is, when you can file it, who can file it, the duration. Now I want to switch gears slightly. The same statutory provisions that allow you to file a mechanics lien also provide a few tools that you can use other than simply filing a mechanics lien. One of them is if you're on a job and you haven't paid someone beneath you, whether justified or not, and it causes them to file a mechanics lien, you can file a demand under the lien law for them to itemize the amount of their lien. And they're not supposed to simply provide you payment applications or invoices. They're supposed to break down labor and materials by component so that you can find out exactly how much they're liening and essentially the backup for that lien amount. Why is that important? Because within the same statutory framework, it says that a lienor is not permitted to willfully exaggerate their lien. What does that mean? If you know you're owed $100,000 and you haven't been paid, but you decide to file a mechanics lien for $400,000, you're going to potentially subject yourself to massive penalties. Because if you know you're not entitled to that additional $300,000, again, you know you're owed $100,000, but you file a mechanics lien for $400,000, the contractor that's above you that hasn't paid you files a request for you to itemize how you come up with your $400,000, and you can't substantiate it. And if that contractor can ultimately prove that you intentionally, you willfully exaggerated your lien amount, you could end up paying the contractor. So even though you're legitimately owed $100,000, you did $100,000 worth of work, supplied a certain amount of materials, you're owed that money. But because out of spite, for other reasons, you decide to file a mechanics lien for $400,000 and you have no justification for it, if the contractor can prove that you did that willfully, here's what the court will do. They're going to take the $400,000 lien amount. They're going to subtract the amount that you were never entitled to, the $300,000, assuming you can prove that you were entitled to the $100,000. They're going to automatically subtract the $3,000 because you were never entitled to that. And then to prove a point, they're going to essentially assess a charge of $300,000 against you. So in my scenario of where you're legitimately owed $100,000 but file a claim of lien for $400,000, you could be put in a position where you actually have to pay the contractor $200,000 because your lien amount is going to get deducted $300,000 off the top because you were never owed. Then the court's going to assess another $300,000 amounts to back charge to you. Since you were legitimately owed $100,000, you could be in a position of owing the general contractor $200,000. So do not, I repeat, do not intentionally inflate your lien amount. Can you make a math error? Yes. Can you include change order requests that were never approved? Yes. Can you include retainage? Most likely. If you legitimately think you're owed the amount of money and can justify it in some way, it's okay to lien for that amount. You can't intentionally exaggerate your number.
Jason, how often do you find the justification and the backup being provided without having to request it in these lien situations?
How often do we have to ask for the backup from a client that is asking us to lien? So I always make sure before I file a lien for a client to make sure I know what the numbers are and that it has some level of backup so they're not opening themselves up to a willful exaggeration. I just like to make sure everything is kosher before we file it, and then they say, "Oh my God, I didn't know," and I wanted to teach this person a lesson. It just opens up a can of worms. So I always ask for some level of backup. So one other tool in the lien law that has nothing to do with a lien, but it's captured in the same area, is what's known as a lien law section 76 demand, a trust fund diversion demand. And whether your time period to lien has expired or not. In other words, you could have lost your right to lien and you can still serve this demand. This trust fund diversion demand is in section 76 of the lien law, and it requires the recipient of the demand. So let's say a subcontractor hasn't been paid and wants to serve this demand on the general contractor. It requires the general contractor, or if the general contractor serves it on the owner, it requires the owner to respond within 10 days. And it requires the response to include a full project accounting. The view from 10,000 feet is the recipient of the demand has to identify every penny they received on the project, when they received it, the form they received it in, every penny that they've spent on the project, how they spent it, when they spent it, the form that they spent it in, any accounts that they deposited money in, contracts with subcontractors. It allows them to provide, it requires them to provide a true full accounting of everything to date on the project. And I will tell you, recipients hate getting them because it is a significant amount of work to respond to them. And oftentimes the responses are not complete. The failure to keep your books and records in a condition that will allow you to provide this full accounting can lead to a per se essential violation isn't the right word, but a per se conclusion that you have diverted trust funds. And a diversion of trust funds is not limited to the corporation or the legal entity. Trust fund diversion can also be tied to anyone that was knowingly involved in that diversion. So, if you're a general contractor, if you're a ARAP person, if you're the president of that company, if you knowingly take money from one project and use it to pay the subs and suppliers on a different project, or you take money from a particular project and use it to go buy a boat, you have diverted funds. And if you were knowingly involved, you have just opened yourself up to personal liability. Let me say that again. If you knowingly involved in a diversion, it's not just the corporation, it's not just the legal entity that's on the hook. You have opened yourself up to personal liability. So the Section 76 demand comes with an awful lot of power, an awful lot of leverage. We use it on a regular basis, and it is an effective tool that has allowed me to get summary judgment in many instances, at least one instance where the person just blew me off, didn't bother to respond to it. That allowed me to easily and quickly make a motion for summary judgment. What I'll also quickly say on the Section 76 demand is it allows you to demand the response to come in one of two forms. You can ask them to provide a verified statement. In other words, provide the accounting that I talked about a moment ago and swear to its authenticity, right, to its accuracy. Or you can also, in that demand, say, instead of getting the verified statement, I'm going to show up at your office, Mr. General Contractor, Mr. Owner, Mr. Subcontractor for that matter, with my accountant on X date, and I'm going to look at your books and records. That scares people. And you have the absolute right to show up after serving the demand and waiting the appropriate period of time to show up and look at their books and records. So with that, I'm going to shift gears from mechanics liens, and I'm going to briefly touch on payment bonds before I turn it over to Mike. So what is a payment bond? A payment bond is, in layman's terms, a security interest. It's another way of trying to get paid on a particular job. More often than not, they're involved in public jobs. On occasion, they will be on private jobs. The private jobs where you have a tendency to see them is what I say are the pillars of the community, right? It's the banks, it's the universities, entities like that are huge structures, that are huge employers within any one community. Oftentimes on their projects, they want payment bonds. So they're almost always on a public job and on select private jobs. So I'm gonna limit it my discussion primarily to public, and then briefly touch on how the rules change a little bit for private. So on public, what is a payment bond? A payment bond is often required, more often than not, required by the owner, the general contractor obtain, and it inures to the benefit of the people who have subcontracts on the project. If you perform work, if you supply materials to a project and you don't get paid, you have a right to make a claim on the payment bond. Whether in the lien fund that we talked about earlier, like so if there's a $4 million job and the owner's already spent $3 million, so there's only $1 million left to go after from a lien standpoint, that concept of the lien fund goes right out the window with payment bonds. You don't have to worry about it. So when there's a payment bond, it's really a cheaper, more efficient way to get paid than a mechanics lien. It's cheaper because when you file a mechanics lien foreclosure action, you have to name all the other lienors, the other people that filed a lien, and they get to be a part of your case. Well, the more attorneys you involve in a room, because there are more subcontractors, more parties, right? The longer the litigation is. You got to herd cats. It's a pain. But if you have a claim on a payment bond, I don't have to name the other lienors. I don't have to name the other claimants on the payment bond. I just get to name Mike's company. Mike doesn't like it. But
the surety company, but yes.
Yes, yeah.
Understood.
Yes. And so so you get a deep pocket to chase that's cheaper and often more efficient than pursuing a lien foreclosure action. And then, so how do you make a claim on a payment bond? So if you're a first-tier subcontractor, so the general contractor provides the payment bond, your contract is directly with the general contractor, you have one time period to keep in mind. You have 1 year, a 1 year statute of limitations. You have to file your cause of action. You have to file your complaint with the courts within 1 year. If you're a second-tier subcontractor, the time periods are twofold. You have the 1 year statute of limitations that I just mentioned, but the other thing is you have 120 days from when you last supplied labor and materials to put the people above you on notice that you have a claim. And who do you have to put on notice? We always say more is better. So if you're a second-tier subcontractor, I'd put the person directly above you on notice. I'd put the general contractor on notice. I'd put the surety on notice. And I'd put the owner on notice via certified mail. I would do it by regular mail. I would do it by email. I would do it as many ways as you possibly can to substantiate, to prove that you have complied with that notice provision, that 120-day notice provision. Because if you don't provide that notice within 120 days, and or you don't commence your action within 1 year, then you forever lose your right to make a valid claim on that payment bond, and your claim against the payment bond goes poof. You still get to go after the general contractor, but if the general contractor is out of business and the lien fund is zero, you might be SOL. So always be mindful of meeting those timing mechanisms. Second tier and below subcontractors, 120 days from when you last supplied labor and materials. and then commence the action within 1 year. You have to meet those deadlines. If you don't, you forever lose your right. Now, on a private job, instead of 120 days, you got to read the bond. The bond, not the statute, will dictate when you have to provide the notice. And 95% of the bonds that I read out there say 90 days. So instead of 120 days, it's 90 days. But you got to get a copy of the bond. On a private job, ask the owner, ask the architect of record. On a public job, how do you get the bond? Same thing. Ask the owner, ask the architect of record. More often than not, they're happy to give it to you because they want to see you get paid. They don't want problems on the job. If you can't get it that way on a public job, if the architect won't give it to you, if the owner won't voluntarily give it to you, file what's called a Freedom of Information request to the public records access officer for that particular entity. Lots of times you can do it online via email and simply ask for a copy of the payment bond. So if you see, and what I've often told clients, as soon as they get on a public job, before things even start to go crazy, make your Freedom of Information request. Ask for the bond so you have it ahead of time in case the crap hits the fan. You're ready to run with it and to put the necessary people on notice in a timely fashion to preserve your rights. Because at the end of the day, no one wants to work for free. You want to get paid. And how do you get paid? Well, you get paid by making sure you get your lien filed on time and you get your payment bond notice in on time and filed on time to preserve your right should you have to commence an action. Should you not get paid by the person upstream of you, you've preserved your right to look at other parties to get paid. And with that, I'll turn it over to Mike.
Yeah, thanks, Jason. So when it comes to payment bonds, I want to talk about three things specifically, and I don't want to get into the history or a payment bond defined. I'm going to talk about the preliminary claims process. Second, I'm going to talk about a payment bond in the sense of and the perspective of a GC requiring a performance and payment bond of a subcontractor. And then third, I want to talk about an actual payment bond live example in the news. So before I get into that, I think Jason had mentioned this, read the bond form. It can vary wildly from owner to owner to owner. So read your bond form, understand it, have your surety professionals review your bond form if it's something that's not a standard AIA payment bond. Just make sure that you understand the language in the bond form. So from a preliminary bond payment bond claims process standpoint, you haven't been paid and you want to perfect your rights through the payment bond. And as much as Jason wishes it was, there's not a blank checkbook, and sureties are not in the business of getting a notification, getting a letter saying we're going to make claim against this payment bond. Oh, well, here, let's write a check, and here's your money that you're due. Doesn't quite work that way. So in this situation and scenario where you haven't been paid, you send notification and put the surety on notice, you can expect that surety's claim department to reach back out to you with a letter and an attached document called a proof of claim document that they'll want you to fill out. They're also going to ask for a litany of information, most likely a subcontract, any purchase orders, any change orders, documentation backing labor hours, material costs, just a whole lot of information. And simultaneously, that claims department's going to send a letter to their client, the principal, and they're going to ask for any valid defense, a written statement, and also a litany of any kind of documentation to back their position. And an investigation will ensue from there. So not quite we put a claim in and can expect to be paid. Now you have to cover yourself, and And I think I mentioned this earlier, communication with your critical partners and key partners is key. Your CPA, your attorney, your surety professionals, you want everyone to be in the loop. So I have another example of a situation where we were contacted by a client who wasn't being paid, and they were looking to potentially cover themselves and put the surety on notice related to the payment bond. And so we said, who is the client that is actually not paying you? And from there, we were able to reach out to the GC, actually to the GC's surety agent, and have the conversation of, look, our client thinks they're due money, legitimate money, they're not being paid, and they're talking about potentially making a claim against the bond. And through conversations and a better understanding, we were able to resolve the situation prior to it turning to a legal, litigious battle of any kind, or people, getting their feathers up because they've now had their surety company dragged into the negotiation or dispute. So I just can't emphasize enough the importance of communicating with your key partners. So just kind of pivoting to the actual general contractor who's just got maybe their largest job and they're contemplating on whether or not to require performance and payment bonds of their critical subcontractors. And if I'm just purely focusing on the payment bond component to that, I think it's always a good practice to have some kind of sub-bonding policy in place. And in the case where you've required a critical subcontractor to provide a performance and payment bond, or we often call bonding back your subs, and let's just play out the scenario where the subcontractor defaults, they go out of business, they're no longer able to continue on with their contractual obligations to you, Mr. GC, and they just happen to have some subs and suppliers themselves who have not been paid. Your payment bond that you've required them to provide will now, actually come into effect and effectively provide the surety notice and require them to make good on the obligation of the payment bond. So just additional food for thought from a payment bond perspective is, as a general, or it could even be a subcontractor that's doing work, and you've got some critical path sub that maybe you haven't used in the past, or just as a general practice of your company, you're going to require them to provide performance and payment bonds. The payment bond does provide you with an additional layer of protection in the sense of, if that critical sub was to go out of business, now the people that were working under them won't call your bond and make a claim against the payment bond. They'll go after the subcontractor that you're working with directly and their surety. So the third item is an actual article in the news that I just, we talk about performance and payment bonds, we talk about hypotheticals. Well, it does happen that the industry of construction is one of the highest failure rates out of any industry. And so as much as any surety professional does not want to think about having a loss, does not want to incur a loss, they do happen. And so I printed off this one article in the news, and I'm just going to read some snippets from it that kind of hit home, in my opinion. So the North Carolina Department of Transportation says a contractor pulling out of 4 projects across the state is to blame for construction delays. Most of our contracts are bonded by payment and performance. Of course, this one was, so we're working with a bonding company to get the project completed. And furthermore, it's a rare circumstance, but DOT promises its bonding company is taking care of it. It's not going to cost the state and taxpayers really any more money because of this, Tipton said. So I just always like to, when I'm talking about payment bonds from a legal and getting paid perspective, the harsh reality is construction companies do go out of business. And when they do, the payment bond that's in place is there to protect the owner and or taxpayers in the sense of now there's some kind of, there's some kind of mechanism that's going to pay subs, suppliers, and labor on that project. So that pretty well covers what I wanted to talk about when it comes to payment bonds. So when we talk about liens from a surety perspective, the main attachment point, in my opinion, is when we have a client who requests a discharge of mechanic's lien bond, and also referred to as a DML bond, or as Jason referred to it as bonding off the lien. So just in general, discharge of mechanic's lien bonds are not a bond that sureties typically prefer. There are sureties that may specialize in DML bonds. However, it's a known issue when you're requesting a discharge of mechanic's lien bond on a construction project. Typically a dispute with a subcontractor or supplier. So unlike a bid or performance or payment bond, which we'll talk about later, the discharge of mechanic's lien bond is indicative of a problem on a project. So, and I'll say this again, communication is key. Communication obviously with your attorney, communication with your surety agent, communication with your surety underwriter, transparency and communication. Sureties do not respond well to surprises. So discharge of mechanic's lien bond, it guarantees that in the ruling of the favor of the subcontractor or supplier, that the GC or owner, along with the surety, will now be on the hook for up to the penal sum of the bond. In New York State, the penal sum on a DML bond is going to be 110%. Now that varies from state to state to state. So if you're doing work in multiple states, you'll want to do your homework and know what the lien law is in each one of those states. There's actually some good resources available that spell out the different lien laws in each state, each of the 50 states. So basically, any surety, when you request the discharge of mechanic's lien bond, will want to know some specific information. They're going to want to know what's going on in the project, why did this sub or supplier lien the project, and what's the likely resolution, kind of what's the narrative in general. So be prepared when you have a situation where you're on a job, someone's liened it, to have a full explanation of the reason why you need to bond the lien off, because any surety will want to know those reasons and what's going on with the project prior to approving and providing the bond. And just fast forwarding, once the actual bond is provided and you now have the discharge of mechanic's lien bond in place, and at the point in time where you want to close the bond out and you no longer need it, even if it's been multiple years, and you're going to pay for it every year that it's in place, it'll renew. So you're going to need one of three pieces of evidence that the surety will require to close that bond out. One would be a letter from an attorney stating that the lien has expired. Secondarily, a court order canceling the bond, and that's part of a court-ordered settlement. The third would be a signed release from the party that's actually put the lien in place, and the result of a negotiated settlement, basically. Now, a letter or an email or a call from your agent or client saying we no longer need the bond in place is not going to suffice as evidence that the surety will accept to close the bond out. because of the nature of the bond. And I want to talk about liens from one other perspective as well, outside of the discharge of mechanics lien bond. So if you have been in a situation where you go and lien a project, you've got some issue going on and you're not being paid, there's a lot of things that can happen, but like I said before, communication is key with your critical partners, being your attorney, your surety agent, your underwriter. And if it's a situation that could turn litigious and go on for quite some period of time, you're going to want your surety to know. We've ran into situations where you have an asset that now it's a receivable or an actual hard asset, but basically you're not being paid, and this is now turned into a hung receivable. And the surety is going to want to know what's going on with that receivable, what's going on with that lien, and what's the likelihood and timeline of you being paid. If they find out via a CPA year-end statement, footnote, or they find out via an AR aging schedule that shows this receivable is 180 days, they're just going to take that out of their analysis, which can affect your working surety program and what you can get for bonds, especially if it's of size and magnitude that does make an impact to the financial overall presentation of what the surety is looking at for your balance sheet. And so transparency, communication is key. We actually had a situation in the past with a client who started working a project. They signed a contract with a developer. They had, confirmed the financing was in place with the bank. They got into the project at least a month in and had done about $3 million of work and hadn't been paid. Now, financing abruptly went away and there was no payment in sight. So in this case, the contractor reached out to us, let us know what was going on, and we worked with the surety to continue to provide surety support and maintain their program in order to keep the things moving that needed to. So I just can't emphasize enough that you might have an issue going on in your business. You might have an issue going on one project that you want to take care of that could really stifle things going forward, but you need to have your critical partners in line and communicate with them on anything when it comes to litigious or liens or having a situation that could affect how a surety is going to look at your balance sheet and make decisions based upon that.
So with that, I'll just wrap things up real quick. As I said, I think at the beginning of this, before the next webinar is published, we're going to give all of you an opportunity to submit questions on this webinar that Mike and I will answer. So send your questions to Tracy and or Phil at the Mohawk Valley Builders Exchange or Northern New York Builders Exchange. They will compile all the questions, send them to Mike and I. If it's depending on if it's a lien question or a bond question, one of us will answer it, and then we will publish on with the next webinar or before the next webinar all of the questions and answers, since you guys aren't here right now to ask them live like we normally have. So with that, we will say goodbye, and I trust you guys all have Tracy and Phil's contact information.
Thanks.